proceed as follows. First, a distortion has been made in the application. The application that was placed before you was not to regulate, but to ban media coverage. And Your Worship, our principal objection is based on the following. Article 28 of the Constitution of this Republic provides in no uncertain terms in clause 1 of Article 28 that in the determination of civil rights and obligations for any criminal charge, the person shall be entitled to fair, speedy, and public hearing before an independent and impartial court or tribunal established by law. Now the emphasis for purposes of our proceedings today is on public hearing. But we shall submit that this public hearing is embedded in it the concept of fair. In other words, public hearing is an essential ingredient for a fair hearing. They are not mutually exclusive but intertwined. Your Honor, there are three principles that are agreed. The first is that it's not an absolute right. The second is that this court has the discretion to determine on whether or not to exclude media coverage or even live streaming, as it was coined. At the beginning, I raised objection against the casual manner with which this application was presented, and this is what I meant. Number one, that without a formal application, it would be difficult for you to determine the four corners of the application. As indeed you heard, the proposed ban was on media coverage, on media coverage of the proceedings. And today, Council is talking about regulated proceedings for coverage. Your Honor, the second reason I refer to the application as casual is that applications of this nature must be supported by evidence. And no evidence was presented. Because indeed, my learned friend, is barred by law from activities at the bar. State attorneys are advocates. And the advocate's professional conduct regulations do not allow us to adduce evidence at the bar. So how then will she adduce evidence to justify the application if it is presented in this informal manner? So we protest the procedure adopted as incapable of arriving or helping this court in arriving at a just, fair, and reasoned decision. Be that as it may, the right to a public hearing is a constitutional right, which is guaranteed and established. Although the law allows a club on the exercise and enjoyment of that right, in Articles 28 and 43, there are qualifications. And clause 2 of Article 28 provides that nothing in subclause 1 of the article shall prevent the court from excluding the press or the public from all or any proceedings before it for reasons of morality, public order, or national security, as it may be necessary in a free and democratic society. So that necessity is the clause.
Can you repeat the exceptions?
The exceptions, Your Honor, public morality, morality, comma, public order, or national security. No more. Yes, we. The state, therefore, bears the duty to demonstrate, and this 28.2 should be read with 43.2. Okay, maybe 1 and 2. That in the enjoyment of the rights and freedoms prescribed in this chapter, no person shall prejudice the fundamental or other rights and freedoms of others. Your Honor, Article 43.2c is the one of particular importance in these proceedings. And it reads as follows: and the limitations in the enjoyment of rights and freedoms prescribed by this chapter beyond what is acceptable and demonstrably justifiable in a free and democratic society, for what is provided for in this Constitution. Now,
I beg your pardon.
Article 43, public interest 2, shall not permit, public interest shall not permit, C, any limitation of the enjoyment have the rights and freedoms prescribed by this chapter. Beyond what is acceptable and demonstrably justifiable in a free and democratic society. Or what is provided in this Constitution. In other words, that for you to strip the accused of the right to a public hearing there are particular safeguards you must have into account. Oh, there are prohibitions placed on this very honorable court by the Constitution. The first is that the state must prove that the three ingredients in Article 28(2), which I mentioned earlier, morality, public order, or national security, one of them will be prejudiced if you allow a public hearing. Your Honor, we want to force a reading of Article 126 126(1) of the Constitution, and I will read. Judicial power is derived from the people and shall be exercised by courts established under this Constitution. And this is one of them. In the name of the people, and in conformity with the law, with the law, law and the values, with the law and the values, norms and aspirations of the people. So the question is, what justification has been placed before your worship to exclude the people in whose name you are exercising judicial power? Is it one of the aspirations of those people that they are locked out of proceedings before a court exercising power in their name? I answer both questions in the negative. It's actually the aspiration of those people, that they follow the proceedings. It was not stated before this court by the prosecution, Your Honor. Forget about proving they have not proved anything, but if not even stated, that a particular set of our morals will be infringed by allowing live coverage of these proceedings. Which morality will be offended? That's number one. Number two, how it is going to prejudice public order. No example of any public trial involving these two particular offenses read here has ever given rise to any public disorder. And because of a public trial, Gombe Town Council, Chibiri Town Council have been locked up in disorder. No example was ever given. Then national security. First, national security cannot be speculatively targeted. And I mark the word speculatively. Targeted a particular witness or officer of court. It was speculated that witnesses might be intimidated by the public. Merely by a witness knowing that he is speaking and that the country is watching constitutes a threat. Or that a state attorney is here in court submitting knowing that the country is watching would constitute a threat to that state attorney. Conversely, the public would applaud their officer that yes, Ms. Rachel, the body is in court doing our job to greater heights by prosecuting a person who promotes disorder. So, the reverse is true, that actually for a public officer doing a public job, you will be applauded for doing a good job on camera. The burden of proof, therefore, to justify this particular application lies on the state to establish necessity, and this necessity is the demonstrable justification going in the Constitution. Necessity, proportionality, and minimal impairment to the right of the accused to a public hearing. In other words, to justify the restriction on that right in a free and democratic society. Your Honor, I find fortification in the decision of the Supreme Court in Charles Onyango versus, and another, Andrew Muwanga versus the Attorney General. We have made copies of the court and the state. We have
Can you have your citation?
in Charles Onyango Board, Your Honor, is Constitutional Appeal number 2 of 2002. I will surrender. Oh. Yes, we have 2, 3 copies. One for all, Your Honor. Your Honor, the first I will refer to the judgment of Sekoko JSC, may he so rest in peace. At page 7, he states that the Commissioner for Civil Litigation's quotation that we should apply subjective test to decide on what is acceptable and demonstrably justified in a free and democratic society.
I beg your pardon.
Justice Sekoko,
Yes, at page 7.
page 7, cites the submission of the Commissioner for Civil Litigation that they should use a subjective test. When the court disagrees, says we must apply an objective test at page 8. It states, the framers of our Constitution consciously opted for an objective test in determining,
Court decided which test? Objective?
decided to apply the objective, not subjective test. In determining what is acceptable and demonstrably justifiable in a free and democratic society. He puts in inverted commas, demonstrably, as used in Article 43(2)(c), appears to connote that whoever wants to show that the act or commission complained of, commission complained of is justifiable. And he says, that person must prove by evidence in our case, the respondent, meaning the Attorney General, should have adduced evidence. Should have adduced evidence to prove that the existence of Section 50 of the Penal Code is justified in a free
Section
50 of the Penal Code Act. Your Honor, this is the section that dealt with sedition as an offense. Is that Section 50 is justifiable in a free and democratic Uganda within the meaning of the current constitution. It states that page 9, as the custodian and guarantor of the fundamental rights of the citizens, a constitutional court, and I emphasize even this court, has a duty upon it of striking down any law which restricts the freedom of speech as guaranteed to the citizens under the Constitution. Your Honor, this judgment was a unanimous one, with all justices of appeal of the Supreme Court agreeing with Justice May. Your Worship, there are key issues for determination before you restrict, exclude, or continue allowing immediate free access. Number one, will live coverage, or even live, they call it live streaming, as coined this morning. Prejudice, public morality, public order, or national security. The court therefore must engage in a discussion that fosters the rights guaranteed in Article 28, 29, 1, A, 29, 1A, 41, which is access to information, and Article 43 of our Constitution. Number two, issue number two, is whether the state has established circumstances justifying the exclusion or even limitation number three, whether the blanket prohibition on live streaming is necessary, proportionate, and demonstrably justified. If we are an undemocratic society that is not free, I will concede with ease. Number four, Your Honor, is there any less restrictive safeguard capable of delivering justice without injuring rights, whether without injuring rights, whether of the accused, the witnesses, and officers. On this one, I will quickly say, yes, there is. That less restrictive measure would be to direct that all proceedings be covered without distortion. The best safeguard for accuracy and transparency is live streaming. Because you can go to write in a newspaper. I'll use my own words. They could distort the actual position of the proceedings. The defense, Your Honor, is aware that even under Section 40 of the MCA, this court is empowered to make orders. For the exclusion either of the public or a particular person not to have access to the courtroom with justification. Your Honor, there are many people outside that have been knocked out of this court. And the reason given is that the court is not big enough to accommodate everybody. It's not that they are disordered, but because this courtroom is not enough. Now you have free expansion of your courtroom through these people's resources. And now the temptation meted out by the state unto you is that no, even those that you would have allowed in, who are not allowed in, close them up. They should not know what is going on in your court. And you exercising judicial power in their name and in their aspirations. Is it their aspiration to be locked out in the court? I answer that in the negative. Your Honor, the statutory provision must therefore be construed in a manner consistent with the Constitution. And this is a command provided unto us under Article 274 of the Constitution. Whenever you're reading the MCA or any other pre-existing law, you're required to read it in a manner but with such modifications, adaptations, and qualifications to bring them in consistency with the Constitution. So, Your Honor, the exclusion is an exception placed onto a guaranteed right. And that standard has been said to be 1, demonstrable justification, and 2, in a free and democratic society. So what is sought to be prohibited would give unadulterated flow of proceedings, would enhance freedom of access to information, freedom of speech and expression, and Article 29(1). Your Worship, the Onyango case decided that you do not clog a right simply because some people regard it as false, erroneous, controversial, or even unpleasant.
They regard it as?
Simply because they regard it as false, erroneous, controversial, or even unpleasant. Merely because somebody has been charged with the offense of, I don't know, managing a lawful society, or inciting violence, does not make it true. It is subject to proof. The nature of the allegation, therefore, cannot be used as a verb to deny the public access to information, contrary to Section 41 of the Access to Information Act.
Section?
Section 41 of the Access to Information. Whose principal objective is promoting transparent and accountable governance. Transparency among all organs of the state, including court. Providing the public with timely, accessible, and accurate information. Nothing has been provided before you alluding to any classification of evidence that is about to be tendered. Enabling the public, the other one is enabling the public to scrutinize and participate in the affairs of the country. Those are the principal objectives of the Access to Information Act. Worship, therefore, for a clawback to be placed on the right, it should not offend both the Constitution and the Access to Information. And the justification justification must be a legitimate objective. That has a connection to the prohibition sought and the principle of necessity.
Has a connection?
The legitimate justification must have a connection to the prohibition sought. I refer to the case of Madrama versus Attorney General. Constitutional Appeal number 1 of 2016. To the effect that once a violation is established, it is the state to justify it. And that justification must not be based on conjecture or speculation. Worship, the fact that the offense charged is said to be a serious one that affects the public. The greater public good would actually justify and account to the public by way of allowing the live stream. If I resort to the other Ugandan authorities, Your Worship, which my colleagues will also help me with, it is important to trace the common law principle of open justice. The House of Lords, in the case of Scott versus Scott,
Common law principle?
yes, of open justice.
Yes.
In the case of Scott versus Scott in 1913, SC 417, did hold that publicity is not an inconvenience. Publicity is not an inconvenience imposed upon courts. It is an essential safeguard of the administration of justice. A departure from this principle can only be in recognized exceptional circumstances. And in a subsequent decision of R, Guardian News and Media Limited, R, in brackets, Guardian News and Media Limited, versus City of Westminster Magistrates Court. Imagine in this case, the case was against court itself. 2012. Westminster Magistrates Court. Brackets 2012. EWCA. Page 420. Court of Appeal, the English Court of Appeal, held as follows. Open justice is a principle at the heart of our system. At the heart of our system. Of justice, of our system of justice. And vital to the rule of law. And this, Your Honor, underpins the principle in the Sussex Justices, R versus Sussex Justices. R versus Sussex Justices, ex parte McCarthy. Ex parte McCarthy, MC capital C-A-R-T-H-Y. 1924, 1 KB, 256, to the effect that justice must not only be done, it, but must manifestly be seen to be done. I will end with two more authorities. One is Indian authority of Swapnil, S-W-A-P N-I-L, Tripathi, that is Tripathi with an H-I, versus the Supreme Court of India. It is a case that dealt with the question of live streaming. Your Honor, it is 20.
Have you given the citation?
Yes. 2018. Close brackets, 10 SCC 639. And the court concluded that open trials and access to the public. Open trials and access to the public during hearing of cases before the court is an acceptable proposition. Unacceptable, AN, Your Worship, for clarity.
It's an acceptable proposition.
Is an acceptable proposition. In that case, Your Honor, the court held that it actually expands access to the courtroom beyond the physical walls, but also educates the public. on the functioning of the judiciary. The South African court, Your Worship, has also gone miles in allowing live streaming as a means of access to information reports. That is the Constitutional Court of South Africa. In the case of
As a means of access?
accessing information in court proceedings, through live broadcasting. I refer to the case of SABC, South African Broadcasting Corporation, versus the National Director of Public Prosecutions.
I beg your pardon? And the parties?
The parties SABC, South African Broadcasting Corporation Limited, versus the National Director of Public Prosecution. That is 2006, close brackets, ZACC 15. That broadcasting enables members of the public to witness proceedings. To witness proceedings which they could not physically attend. Further than physical public presence does not necessarily inhibit judges, counsel, and witnesses. The mere fact that members of the public are watching remotely does not automatically establish such inhibition. Does not automatically establish such inhibition. And that it is less intrusive, and therefore justifying. As I conclude the worship, before I hand over to my colleagues to introduce the other authorities, permit me to say, one, that the state has miserably failed to justify a case of locking out citizens from the proceedings of this court. That evidence could have been brought by way of affidavit with real-time data. Short of which it is only conjecture. Actually, the state must also style up, and I mean the government of Uganda.
Mind your language.
I am minding it. to justify it?
It should have been brought by affidavit.
By affidavit with real-time data attached to that affidavit. The language I am using, Your Honor, is basic English of the state styling out. How? Bringing to court cases that are justified. I conceive this application as one that is intended to shield the government or the state in terms of its inadequacies. It should not be open to the state. And you should not referring to the representatives here. These are lawyers representing the state. It is not, should not be open to the state to bring embarrassing cases and then say,
Objection, Your Worship. Council needs to address court with decorum and avoid insinuating unverified information.
how would she know it is verified before I speak out? I'm going to
You're
speak out.
referring to the cases as embarrassing.
Yes.
How verified
I'm
is
going,
that?
I'm going to demonstrate. We just need to be patient. Your Worship, if the case is not embarrassing, the state,
Objection upheld.
Mr. Blair.
before I conclude.
Upheld.
Okay, I'm silent.
Okay, proceed.
Your Worship, if the accused person committed offenses against the public, and the state has done its thorough job in investigations and prosecuting, why would they not want the public to see as they expose the criminal in the dock that this is a man who propels public disorder, responsible for your lack of sleep, is here. The police has consistently been parading before the public people they have arrested. And they say the person terrorizing Kampala is here. Now the person terrorizing Utambala is here, and they do not want the public to see him prosecuted. That is dishonest, and that's what I mean. In the interest of justice for both parties, the accused objects to trial in camera and secrecy. The accused submits to public scrutiny. Let witnesses come and show that this man is a danger to society. He accepts. Therefore, we pray that you do not accept to make a job into a scheme of secrecy that is intended by the state. And for the rest of the authorities, Your Worship, we say we want to make a good case for you, not to run our defense casually. We have more authorities from the Ugandan courts, which my colleagues are ready to cover. Thank you, Your Worship.
For the record, Your Worship, former chief, joint also representing the accused. I thank my senior brother for all the submissions. As he has notified the court, Your Worship, I'm just only adding a few Ugandan cases to qualify that his application is dead on arrival. Your Worship, first of all, I'll address you on the decision of High Court. Miscellaneous cause number 87 to save court's time.
The parties?
Uganda Court Reporters Association Limited. Uganda Court Reporters Association Limited against the AG. I'll draw your attention, Your Worship, to page 10.
Will you tell me the citation first?
It's miscellaneous cause number 87 of 2014. Miscellaneous cause number 87 of 2014.
Okay.
I'll address you, Your Worship, from page 10 to 14. A few highlights court mentioned. One, I'll start with page 11, paragraph 34, which buttresses the point senior counsel has presented that applications of this nature require evidence. You don't come to court and just make an application orally. They require evidence substantiated through affidavits duly administered before a commissioner for oath, and all a witness standing in court and takes oath. You don't come and talk and call that an application. 34, His Lordship is referring, saying that he's referring to Her Lordship was referring to a decision, referring to a decision where it said on line 3 that Justice Masenke DCJ at page 39, referring to the above decision, explained that although the right to obtain justice is not absolute, in each case where derogation is sought,
Although the right to open justice.
much obliged, that justice explained that although the right to obtain justice is not absolute, in each case where derogation is sought, the court will have to weigh the competing rights of interests. Carefully, with a view to ensuring that the limitation it places on open justice is properly tailored and proportionate to the end it seeks to attain. This is further important. The court is obliged to have regard to all factual matters. You should emphasize that. To all factual matters and factors before it, in order to decide whether a limitation on the right, the right to open courtrooms, passes constitutional muster. she further qualified that in evaluating the competing constitutional claims, premised on open justice on one hand, and in national state security, on the other. The starting point is to recognize the vital, significance of openness of court proceedings and records. You should bring that to the case before you. We don't have factual evidence to guide this court to weigh the competing interests. We only have submissions on the back that the cases of a serious nature, which statement alone needs qualifying by way of adducing evidence. That's why I'm saying the application is dead on arrival. Under paragraph 38, your worship, of the same decision, 38 on page 12. The last sentence is critical. The court is of the view that to justify any order for hearing in camera, and that is the exclusion of media coverage, live streaming, and so on. To justify an order for hearing in camera, it must be shown that the paramount object of securing that justice is done would really be rendered doubtful. If the attainment of the order were not met. Both the defense team, your worship, and this court have been left in suspense. It is only the state that knows the paramount object. And the requirement here is mandatory. It must be shown. You cannot do that without evidence of record. And you should
They know the paramount what?
Object, because they have not given us evidence, and this court, to know what they exactly mean, they've reserved that to themselves. That's not passing the test of the requirement of an application of this nature. And on page 13, your worship, paragraph 41, the burden senior counsel in submission are talked about has been reiterated there under paragraph 41 on page 13, that the burden of displacing the general rule of openness of judicial proceedings,
The burden of?
the burden of displacing the general rule of openness of judicial proceedings lies on the party making the application, in this case the state. And this is very critical, Your Worship, I'm reading. And that there must be sufficient evidentiality. It is not on preponderance. There must be sufficient evidential basis from which the trial court must assess the application. And upon which it may exercise its discretion judicially, and upon which it may exercise its discretion judicially. If I pose a few questions to trigger this honorable court's decision. One, where is the sufficient evidence to support this application, if any? Two, what is this honorable court going to use to assess this application in the absence of evidence? Three, who bears the burden to present this evidence? And lastly, in the absence of such evidence, how can this honorable court exercise its discretion? Which of the answers to those questions are very obvious, and my colleague state is already confirming that really this is a non-starter. Lastly, Your Worship, the decision of still High Court of Uganda, this is High Court of Uganda sitting at Kampala, Commercial Division.
The parties?
We have, Your Worship, their Indian names, allow me to mention only Patel, others I cannot read well. Patel and the 5 others against Patel and 10 others. Your Worship, it is in miscellaneous application number 768 of 2021. 768 of 2021.
768
of 2021. Of particular importance is page 11. Page 11, lines 15 to 25, where His Lordship, Justice Stephen Muwanga, gives the emphasis of Article 28(1) of the Constitution. In this case, we're referring to civil proceedings, but 28(1) refers to both civil and criminal.
Emphasis to Article
28(1) of the Constitution. 28(1) of the Constitution, referring to civil proceedings, which same provision also applies to criminal proceedings. And you should allow me to read what he says, that
the same applies to criminal proceedings.
criminal proceedings, 28(1), it's both civil and criminal proceedings.
Yes.
His Lordship says here that this Article 28(1) guarantees every citizen a right to a public hearing. It guarantees a right to public hearing. It goes on further to state that the public hearing guarantee, comprises two distinct aspects. One, an individual right of the litigant. Two, an institutional guarantee. An institutional guarantee, that is a way of ensuring